Hi there, John Farrell with the Farrell Law Firm. Estate planning can feel overwhelming, and while creating a living trust is one of the smartest steps you can take to protect your legacy, there's a lesser known side to this process, what you shouldn't put in the trust. In this video, I'll not only walk you through the types of assets that don't belong in a living trust, but I'll also explain why. We'll cover real life scenarios, practical tips, and the potential pitfalls of making the wrong decisions. Stick around to the end where I'll share some bonus advice to optimize your estate plan and avoid common mistakes. Let's start with vehicles. Cars, motorcycles, boats, RVs, and so on. People often think they need to retitle all of their title assets into their trust, but vehicles are an exception. Here are the top 3 reasons vehicles don't belong in your trust. Number 1, there can be a simpler transfer after death. In most states, vehicles can be transferred to beneficiaries with a death certificate and a simple DMV form. There's no probate involved, so there's no need to complicate things by putting them in your trust. For example, let's say you have a car you want to leave to your son. Rather than retitling it into your trust, you can include instructions in your estate plan. When the time comes, your successor trustee can easily handle the transfer. Number 2, there may be liability concerns. If your vehicle is titled in the trust name and is involved in an accident, it could expose your trust to lawsuits. A trust can be perceived as having deep pockets, making it an attractive target for attorneys. For example, imagine you loan your car to a friend who gets into an accident. If the vehicle is in your trust name, the injured party may go after your trust assets in a lawsuit. Number 3, it can cause insurance complications. Insurance companies often struggle to insure vehicles held in a trust. While it's possible, it can lead to confusion, increased premiums, or even coverage gaps. Here's a pro tip. Keep vehicles in your name, but leave clear instructions in your trust for who should inherit them. Now let's talk about life insurance. Like retirement accounts, life insurance policies don't belong in your trust. Here's why. Number 1, it already avoids probate. Life insurance proceeds go directly to the named beneficiaries without needing to go through probate. Number 2, there can be estate tax planning. If your estate is large enough to be subject to estate taxes, consider using an irrevocable life insurance trust or ILIT. This keeps the policy outside your taxable estate, reducing potential taxes. When should life insurance be tied to a trust? If you want to ensure the proceeds are managed according to your estate plan, name your trust as the beneficiary. This is particularly useful if you're leaving money to minor children or if you have specific goals for how the funds should be used. Here's an example. If you pass away, naming your trust as the beneficiary ensures that the funds are used to support your children's education or other goals, rather than being handed over outright. Now let's dive into retirement accounts, IRAs and 401ks. These are some of the most common assets people ask about when funding their trusts. And here's the simple answer: don't do it. Why? Retirement accounts are governed by specific tax rules, and transferring ownership to a trust could cause unintended consequences, like triggering a taxable event. Let's say you have a $500,000 IRA and you decide to retitle it into your living trust. This could be considered a full withdrawal, meaning you'd owe income taxes on the entire amount that year. That's a mistake no one wants to make. What's the solution? Instead of transferring ownership, choose amongst your spouse and family members as the beneficiaries. When you pass away, these assets will flow into your family and be distributed according to your wishes. Here's some advanced estate planning. If you have younger beneficiaries like children or grandchildren, your trust should include language to manage how funds are distributed. This is especially important for minors or young adults who may not be ready to handle large sums of money. For example, your trust could specify that funds are distributed in installments, say 50% at age 30 and the remainder at age 40, rather than as a lump sum. Don't transfer retirement accounts to your trust. Before we wrap up, and as a bonus, let's quickly go over some common estate planning mistakes people make and how to avoid them. Number 1, forgetting to fund your trust. A living trust only works if it's funded. That means transferring assets like real estate, bank accounts, and investments into the trust name. Number 2, not updating beneficiary designations. Your trust might be up to date, but if your retirement accounts or life insurance policies still name an ex-spouse as the beneficiary, you've got a problem. Review these designations regularly. Number 3, overlooking digital assets. From online banking to social media accounts, digital assets are often overlooked. Make sure your trust includes instructions for accessing and managing these accounts. Here's a pro tip. Review your estate plan every 3 to 5 years or after major life changes. So there you have it. Vehicles, life insurance, and retirement accounts are the 3 main assets to keep out of your living trust. By understanding what belongs in your trust and what doesn't, you'll avoid costly mistakes and ensure your estate plan works the way you intend. If you found this video helpful, hit the like button and share it with someone who's working on their estate plan. And don't forget to subscribe for more tips on protecting your legacy. Have any questions? Drop them in the comments or reach out to our team to schedule a consultation. Thanks for watching.